On April 29, 2026, the Supreme Court of the United States handed down a decision that rewired the rules of American democracy, and most of the country did not notice until it was too late to stop what came next. It did not happen with a headline about voting machines or a dramatic election night dispute. It happened with a ruling most Americans never read, in a case about district boundaries in a single state, decided on a spring afternoon, while most of the country was focused on other things. The case was called Louisiana versus Calais. 6 justices signed on to the majority opinion. 3 dissented. And by the time the ink was dry, Section 2 of the Voting Rights Act of 1965, the single most important tool black voters have had for 60 years to fight discriminatory maps, had been fundamentally rewritten. Within weeks, Republican legislatures from Columbia to Atlanta to Nashville were pulling out new congressional maps designed to erase some of the only black-held seats left in the American South. This is the story of what the Supreme Court did, why it did it, and what happened when ordinary voters found out. Voting Rights Act, Supreme Court, redistricting, Congress, the 2026 midterms. Keep those words in your head, because you are going to hear them a lot over the next few minutes, and by the end, you will understand exactly why they matter to you, no matter what state you live in. Before we go further, if breakdowns like this are useful to you, if you like having the legal jargon translated into plain English before the consequences land in your own backyard, go ahead and hit subscribe now. It helps this channel keep doing this kind of research, and it costs you nothing. Now, back to the story. Here is the quick version for anyone just catching up. The Voting Rights Act was signed into law in 1965, after decades of violence and legal trickery kept black Americans away from the ballot box across the South. The original law had 2 main enforcement tools. One was called preclearance, and it required states with a history of discrimination to get federal approval before changing any voting rule, including district maps. The Supreme Court gutted that tool back in 2013 in a case called Shelby County versus Holder, ruling that the formula used to decide which states needed federal approval was outdated. Once preclearance was gone, Section 2 became the main remaining shield. Section 2 does not require a state to admit it discriminated on purpose to be found in violation. For decades, it only required proof that a map, in practice, gave minority voters less opportunity to elect the candidates of their choice than white voters had. Courts checked that using a framework built in a 1986 case called Thornburg versus Gingles, which asked whether minority voters were geographically concentrated enough to form their own district, whether they voted cohesively as a group, and whether the white majority tended to vote as a bloc against their preferred candidates. If all 3 conditions were met, a state generally had to draw a district that gave that minority community a real chance to elect its own representative. It helps to remember why the Voting Rights Act exists in the first place, because the current fight only makes sense against that backdrop. Before 1965, several southern states used literacy tests, poll taxes, and outright intimidation to keep black citizens from registering to vote at all, not just from winning elections, but from casting a ballot in the first place. The turning point that finally forced Congress to act came in March of 1965, when state troopers attacked peaceful marchers crossing the Edmund Pettus Bridge in Selma, Alabama, an event broadcast into American living rooms that shifted public opinion almost overnight. Congress passed the Voting Rights Act months later. It worked. Black voter registration across the South climbed dramatically within a few years, and over the following decades, the number of black elected officials nationwide grew from a few hundred to many thousands. That growth did not happen automatically. It happened because federal law forced states to stop drawing lines that made black votes count for less than white votes, first through preclearance, then, after Shelby County versus Holder eliminated preclearance in 2013, almost entirely through Section 2, understanding that 60-year arc is what makes the Calais decision land as more than just another technical legal ruling. It is the latest turn in a fight over the same basic question the country has been arguing about since 1965, whether the law will actively require fair maps, or whether it will simply stop actively requiring anything and let whoever controls a state legislature decide how much political power a minority community gets to keep. For nearly 40 years, the Thornburg versus Gingles framework is the reason cities like Memphis and states like Louisiana, Alabama, and South Carolina have had black members of Congress at all, in numbers that come anywhere close to matching their share of the population. Take that framework away or make it functionally impossible to use, and in several states, black congressional representation could fall by half or more within a single election cycle. That is not speculation, that is basic math applied to maps that already exist, and it is exactly what the Calais decision put in motion. Here is what happened. The dispute in Calais began years earlier, when a federal court ordered Louisiana to draw a second black majority congressional district, on top of the one it already had, because the existing map diluted black voting strength under Section 2. Louisiana complied, reluctantly, and drew a new district that snaked across the state to connect black communities in Baton Rouge and Shreveport. A group of self-described non-black voters then sued, arguing that the new district was itself an unconstitutional racial gerrymander, because race had been the predominant factor in how it was drawn. That set up a genuine legal collision. One line of Supreme Court precedent said states sometimes have to consider race to comply with the Voting Rights Act. Another line of precedent said states are not allowed to make race the predominant factor in drawing districts. Louisiana was caught in the middle, ordered to fix one violation by a method the court would later say created a different one. The documents show that this case did not move quickly, and the slow pace itself became part of the story. It was first argued in March of 2025. Court watchers expected a relatively narrow ruling on Louisiana's specific map. Instead, the justices did not decide it then. They ordered a second round of arguments for the fall, an unusual step that legal reporters immediately flagged as a signal something much bigger than one state's map was under consideration. That second argument happened on October 15, 2025, and by then it was clear the court was weighing whether to rewrite the constitutional test for Section 2 itself, not just resolve a dispute over one Louisiana district. Legal analysts spent the winter of 2025 and early 2026 publishing piece after piece asking the same question. Was Justice Alito, who wrote a concurrence years earlier, questioning whether courts should keep assuming compliance with the Voting Rights Act was a compelling government interest, about to get the votes he needed to turn that question mark into a period? The decision finally landed more than 6 months after the second argument, on April 29, 2026, timed almost perfectly to hit the middle of a redistricting season that was already the most chaotic in more than half a century. And the timing created an immediate separate legal fight of its own. Under the court's normal rules, a decision does not become official and enforceable for at least 32 days, giving the losing side time to ask for reconsideration. Louisiana's governor did not wait. The day after the ruling, he signed an executive order convening the state legislature, and a 3-judge panel back in Louisiana declared the state was free to enact a new, constitutionally compliant map immediately, even though the Supreme Court's own judgment had not yet been formally entered. That triggered new emergency litigation almost overnight, with the dissenting justices warning that the majority's own procedural shortcuts were being used to justify rushing changes into an election that was already underway. Here's where things changed. Justice Samuel Alito wrote the majority opinion, joined by Chief Justice Roberts and Justices Thomas, Gorsuch, Kavanaugh, and Barrett. The court did not strike down Section 2 outright. What it did was narrower, and in some ways more consequential, because it changes how every future Section 2 case will be judged. According to the opinion, Section 2 now imposes liability only when there is strong evidence that a state intentionally drew its districts to give minority voters less opportunity because of their race. In plain English, that shifts the legal test from, does this map produce a discriminatory result, to something much closer to, can you prove the state meant to discriminate? That is a dramatically higher bar. Proving intent is hard. Proving a state's inner motive, when legislators can simply say they were chasing partisan advantage instead of racial advantage, is sometimes close to impossible. As Justice Alito put it in the opinion itself, the Voting Rights Act, quote, was designed to enforce the Constitution, not collide with it. That single sentence is now the North Star for how lower courts will read Section 2 going forward. Justice Clarence Thomas, joined by Justice Gorsuch, went further in a separate concurrence, arguing the court should have gone all the way and ruled that Section 2 cannot be used to challenge redistricting maps at all, under any standard. The majority did not adopt that position, at least not yet, which is one reason legal analysts describe Calais as a narrowing of Section 2 rather than its outright repeal. But Thomas's concurrence matters because it signals that at least 2 justices are ready to finish the job in a future case, and lower courts now know that when they write their opinions. Justice Elena Kagan wrote the dissent, joined by Justices Sotomayor and Jackson. Her warning was blunt. She wrote that the ruling, quote, renders Section 2 all but a dead letter. That is not commentary from an activist group. That is language from a sitting Supreme Court justice, in an official dissenting opinion, describing what her own colleagues had just done to a law that has stood for 6 decades. Kagan also raised a sharper point about how the majority treated the overlap between race and party. She argued that in a country where voting patterns split heavily along racial lines, pretending partisan motive and racial motive can always be cleanly separated lets a state discriminate against a racial group and simply call it politics. Reaction from outside the court followed similar lines. The Na-Akip Legal Defense Fund called the ruling a devastating blow to a critical civil rights protection. MALDEF said the decision blesses racially discriminatory gerrymandering and invites states to dilute minority voting strength. Neither organization claimed Section 2 had been erased from the books entirely. Both said, in slightly different language, that it had been made far harder to use. Now here's the legal jargon, translated. When courts talk about strict scrutiny, they mean the toughest level of judicial review that exists, the standard applied whenever a government uses race as a factor in a decision. Under strict scrutiny, the government has to prove it had a compelling reason, and that it used the narrowest possible method to achieve it. Before Calais, most courts treated compliance with the Voting Rights Act as an assumed compelling reason. After Calais, that assumption is gone. States now have to justify race-conscious map drawing at the highest legal bar that exists in American law, while also proving discriminatory intent to trigger Section 2 in the first place. Why does that matter to you if you have never sued anybody over a map in your life? Because it means the tool that used to force states to draw fair districts for Black and Latino communities now requires a nearly impossible combination of proof. Intent is hard to prove. Race-conscious remedies are hard to defend. States that want to draw maps that squeeze minority political power now have a green light they did not have 6 months ago, and Republican legislatures across the South noticed almost immediately. It helps to say plainly what a congressional district actually controls, because representation can sound abstract until you connect it to specifics. A member of Congress votes on federal spending that funds local hospitals, school districts, and infrastructure projects. They decide through committee assignments whether a community's flood control funding, broadband expansion, or disaster relief request gets serious attention or gets buried. They are often the loudest local voice in Washington when a factory closes, a military base is threatened, or a public health crisis hits a specific region hard. When a majority Black district gets cracked into 3 whiter, more rural districts, the communities inside it do not just lose a preferred candidate. They lose the built-in leverage of being the majority of somebody's voters, the leverage that makes a representative's career depend on showing up for them specifically. That is what is actually being negotiated in these redistricting fights, underneath all the legal terminology. 2 more terms are worth translating here, because you will hear them constantly in every state fight this video covers. The first is majority-minority district, which just means a district drawn so that Black voters, or Latino voters, or another minority group make up more than half the voting population, giving that group a realistic chance to elect a candidate of their choice, rather than being outvoted every time by a white majority spread across several districts. The second is the pair of terms packing and cracking, the 2 basic gerrymandering techniques mapmakers use against a group they want to weaken. Packing means cramming as many of that group's voters as possible into 1 or 2 districts, so they win those seats by enormous, wasted margins while having no influence anywhere else. Cracking means the opposite, splitting a concentrated community across several districts where it never reaches a majority in any of them. Tennessee's new map, which spreads Memphis's Black voters into rural districts stretching hundreds of miles away, is a textbook example of cracking. Understanding those 2 words is the difference between reading a redistricting story as abstract legal theory and understanding exactly what a new map does to your own ability to elect someone who represents you. One more piece of jargon, because you will hear it in nearly every court filing this fight produces: the predominant factor test. Courts use it to decide whether race, rather than ordinary politics, drove how a district was drawn. In practice, judges look at things like whether a district's boundaries make geographic sense, whether they follow county or city lines, whether they split communities that have nothing in common except race, and whether mapmakers had detailed racial data in front of them while drawing, as opposed to political data like past election results. Louisiana's second majority Black district lost in Calais, partly because the state's own defense conceded the district existed specifically to satisfy a court's demand for a second Black opportunity seat, which made race, almost by definition, the predominant factor a court could point to. States defending their maps after Calais are now working hard to make sure the paper trail shows political data driving their decisions instead, because that paper trail, more than almost anything else, is what a judge will read first. I want to pause here for something that matters if you're trying to understand where the full story is headed. I've put the complete story together in my new book titled The American Reckoning: Trump, Power, and the Battle for America's Future. It is a fully sourced, chapter-by-chapter account of what has really happened to American power since 2025, the courts, the money, the media war, and what comes next. No spin, just the record. You can get it through the website link in the video description or check the pinned comment. Now, back to what happened after the ruling came down. The first place the fallout hit was South Carolina, and it hit fast. South Carolina's 7 congressional seats currently include just one, held by a Democrat, Congressman Jim Clyburn, the longtime House Majority Whip and the most powerful black political figure the state has ever produced. Clyburn has held that majority black district for 34 years. Within weeks of the callous decision, South Carolina House Republicans introduced a new map designed to eliminate it entirely, aiming to give the state's congressional delegation a clean 7-0 Republican sweep. Public records show State Representative Ralph Norman, who was also running for governor, argued openly that Republican supermajorities in the legislature existed to be used, and that a fully red delegation would help hold the state's seats for President Trump's agenda in Washington. The House passed the new map after a midnight vote that stretched past midnight on May 20th, sending it to the state Senate. The Senate Judiciary Committee then held hours of public testimony the same day, hearing from residents on both sides of the plan, along with South Carolina's newly appointed director of the State Elections Commission, who walked lawmakers through what the compressed legal timeline would mean for the state's already scheduled June primary. Legislators were told that redrawing the lines this late could force a delay of the primary itself, a detail that made the political stakes even more immediate for candidates already on the ballot. But the problem for Republicans was what happened next. Word of the plan reached voters fast, and South Carolina's primary was scheduled for June 9th. Reports from early voting sites described lines that dwarfed anything seen in recent memory. More than 26,000 ballots were cast by noon on the very first day of early voting, compared to roughly 125,000 cast over the entire 2-week early voting period 4 years earlier, and turnout skewed nearly 5-1 toward Democratic ballots, a lopsided margin that state party officials on both sides read as a direct message about the map fight. Clyburn himself cast an early ballot in Orangeburg in the district Republicans were trying to erase. According to reporting from CNN and NPR, Democratic organizers had explicitly called on voters to turn the primary into a referendum on the map. It worked. On May 27th, the state Senate declined to advance the House-passed plan. Clyburn's district survived, at least for now. He wrote publicly that a critical number of Republicans in the legislature had refused to put loyalty to a single man above the constitutional principles they claimed to believe in. Norman, for his part, said he still respected Clyburn personally, even while pushing to eliminate the seat he holds. It's worth noting that South Carolina's state senators were not themselves on the ballot this year, which means the pressure that moved them was not fear of their own re-election. It was something closer to a read on where the broader electorate's temperature was heading into November. That's not the end of the South Carolina story, and it isn't the end of the broader pattern either, because almost the same sequence played out 3 states away in Georgia. What nobody outside Georgia fully expected was how fast the backlash there would organize. After the Calais decision, Governor Brian Kemp called a special legislative session for June 17th, aimed at redrawing not just Georgia's congressional map, but its state legislative maps as well, changes that would not take effect until the 2028 elections, but that would lock in new lines before Kemp left office at the end of his term. State Senator Nikki Merritt, who chairs the Georgia Legislative Black Caucus, said publicly that the redraw would touch every level of elected government in the state, not just Washington. Voting rights advocates, including groups affiliated with the ACLU and the Southern Poverty Law Center, began organizing protests before the session even began. There is a detail in the Georgia timeline that is easy to miss and worth pointing out, because it changes how the story reads. Kemp is term limited and leaves office at the start of next year. It was 3 months ago tonight. Calling the special session before he departs meant any new map could be locked in under his signature before there was any chance a Democratic successor could block it. That is a legal and political calculation Republicans in the legislature discussed openly, not a hidden motive reporters had to dig for. On the day the special session opened, the Georgia state capitol filled with demonstrators, described by multiple outlets as hundreds, possibly thousands of people packing the rotunda and the halls outside the chamber, arriving even as the city prepared to host matches for the FIFA World Cup, an event organizers had hoped would dominate that week's headlines instead. Senator Raphael Warnock joined the protest in person, telling the crowd that there is a reason legislatures draw lines that concentrate black voters together, and that erasing those lines erases representation, not just abstract political advantage. Isabel Otero, the Georgia policy director for the Southern Poverty Law Center, told reporters the session amounted to an attempt to weaken black voting power directly. State Representative Tanya Miller told reporters, simply, that in a democracy, voters choose their leaders, not the other way around. Protesters carried signs reading, "Free and fair elections," and "Protect black voters," and chants of "No new maps" reportedly filled the rotunda for much of the day. Less than an hour before lawmakers were set to gavel in, Republican legislative leaders, including Senate President pro tempore Larry Walker and House Speaker John Burns, announced they would not pursue redistricting during the session after all. They cited pending litigation elsewhere in the country as a reason to wait, while insisting publicly that any future Georgia map would ultimately survive a court challenge. The rotunda, according to multiple local reports, erupted in cheers when the announcement came. One protester, Kayla Garthus, told a local outlet she was glad to see Republicans back down, but she made clear the fight was not over, only paused. State Representative Jasmine Clark, the Democratic nominee for Georgia's 13th congressional district, a majority black seat that had been considered a likely target, called it a massive victory for the people who organized against the maps because they understood what was at stake. Line the three states up side by side, and a pattern starts to emerge that is worth naming directly. In South Carolina, the map never got past the state Senate. In Georgia, the map never got past the announcement stage, shelved less than an hour before lawmakers gavelled in. In Tennessee, the map passed both chambers and is already the law the state's November election will use. The difference was not the underlying legal environment, which was identical in all three states after Calais. The difference was timing and political exposure. South Carolina's House Republicans faced no immediate election of their own when they folded, but felt the heat from a primary already underway. Georgia Republicans faced a special session called specifically to beat a deadline and backed off the moment public pressure made the political cost visible before any vote was cast. Tennessee Republicans, holding some of the largest legislative supermajorities of any state in this fight, calculated that a Memphis-based backlash, however large, could not realistically flip enough seats in the state legislature to threaten their control, and they were right about that calculation, even if the trade-off is a genuinely competitive November race in the new 9th District. 3 legislatures, 1 Supreme Court ruling, 3 different bets about how much political risk a new map was worth, and 3 different outcomes. This changes everything about how you should think about the word inevitable in this story, because inevitable is exactly what Republican strategists assumed a post-Calais redistricting push would be. It was not. In South Carolina and Georgia, organized public pressure, translated into both street protest and ballot turnout, stopped 2 separate mid-decade redistricting efforts in their tracks. But Tennessee tells a different, more complicated version of the same story, because in Tennessee, the map did go through. Tennessee's only majority black congressional district for decades has been centered on Memphis and Shelby County. After the Calais decision, Tennessee's Republican-controlled legislature moved to break that district apart, spreading Memphis's black voters into wider, more rural, more conservative districts that stretch for hundreds of miles beyond the city. Demonstrators gathered at the Cordell Hull building in Nashville during the special session in early May, filling committee rooms and hallways as lawmakers debated the new lines. But unlike in Georgia, Tennessee Republicans, who hold supermajorities in both chambers, pushed the new map through anyway, making Tennessee one of roughly 10 states nationwide to adopt a new congressional map in this cycle. What happened next in Memphis is the part of this story that deserves the most attention, because it shows what organizing looks like after you lose the first fight, not before it. Local pastors, civic groups, and organizers, including Pastor Earl Fisher of Abyssinian Missionary Baptist Church and the founder of a Memphis turnout organization called Up the Vote 901, began an aggressive push to register and mobilize voters ahead of Tennessee's August primary, the first real test of the new map. It was 3 months ago tonight. Fisher told reporters that the standard for representation should not be whether one person can represent everybody, but whether a representative can honor the will of the majority in the district while still respecting the dignity of everyone who lives there. The tone in Memphis, by multiple accounts, was less despair than determination. On August 6, 2026, Tennessee held that primary, and turnout in Shelby County told its own story. The vast majority of ballots cast, more than 56,000 of roughly 90,000 total votes, came through the Democratic primary and early voting, even though the new 9th congressional district now tilts Republican, with an estimated 71% of its voters newly added from outside the old district lines. State Representative Justin Pearson, one of the so-called Tennessee 3 lawmakers expelled from the state legislature in 2023 after protesting for gun reform, won the Democratic nomination for the redrawn seat, defeating State Senator London Lamar and two other candidates, physician Jim Torino and community activist LaTroy Alexandria Williams. Lamar had built a coalition of her own, backed by endorsements from Congressman Steve Cohen, former Memphis Mayor Willie Harrington, and current Shelby County Mayor Lee Harris, arguing her legislative record made her the stronger fit for Congress. Pearson's win over that coalition is itself part of the story, a sign that the district's Democratic base leaned toward the more nationally recognized, activist-aligned candidate over the establishment-backed one. On the Republican side, the primary produced its own upset. Incumbent Congressman Andy Ogles was ousted in his own primary election the same night, a result Al Jazeera's election night coverage flagged as further evidence of how unsettled the new maps have made Tennessee's entire congressional landscape, not just the seats centered on Memphis. In the redrawn 9th District, Republicans chose State Senator Brent Taylor, endorsed by President Trump, to face Pearson. Analysts describe the seat as now leaning solidly Republican under its new boundaries, which means Pearson's primary win is a genuine grassroots story, but an uphill battle in November, not a guaranteed comeback. The race is now expected to be one of the most closely watched House contests in the country this fall, precisely because it sits at the intersection of the redistricting fight and the broader battle for control of Congress. Here's the part investigators keep coming back to when they zoom out from any single state. South Carolina, Georgia, and Tennessee are not isolated dramas. They are 3 data points in a much larger national pattern that started before Calais was even decided and accelerated hard once the ruling came down. It's worth sitting with why redistricting even happens on this kind of compressed timeline in the first place, because it is not how the process is designed to work. Ordinarily, states redraw congressional lines once per decade, right after the census, specifically to avoid turning district maps into a constant, campaign-by-campaign political weapon. Mid-decade redistricting was rare enough, before this cycle, that most sitting members of Congress had never experienced their own district being redrawn outside the normal 10-year schedule. That norm held for roughly 50 years, through administrations of both parties, not because it was legally required in most states, but because both parties generally treated it as bad precedent to set, the kind of move that invites endless retaliation once you start. This cycle broke that norm first in Texas, and every state that followed, on both sides, has cited the one before it as justification. That is part of why this story is bigger than any single court case. Even if every current legal fight resolved tomorrow, the norm against mid-decade redistricting itself may already be gone for good, which means future House majorities on both sides may now treat redrawing the map midterm as a standard tool of the job rather than an emergency measure, unless Congress or the courts eventually draw a new line around it. Let's back up to the timeline for a moment, because the sequence matters, and this is where the story stops being purely about race and becomes about raw partisan math too. Long before the Supreme Court ruled on Louisiana, President Trump had already publicly pushed Republican-controlled states to redraw their congressional maps mid-decade, outside the normal once-a-decade census cycle, specifically to protect the party's narrow House majority heading into the 2026 midterms. Texas moved first, passing a new map that Governor Greg Abbott signed into law, adding Republican-leaning seats by reshaping districts around Houston, Dallas, and Austin, a plan projected to yield as many as 5 additional Republican seats. Texas Democrats attempted to block the map by leaving the state to deny the legislature a quorum, a tactic that delayed, but did not stop, the new lines from becoming law. A lower court initially found the Texas map likely amounted to a racial gerrymander, but the Supreme Court allowed it to be used for this election anyway, a preview of how the justices would later rule in Calais. Missouri followed with its own special session that September, targeting the Kansas City area seat held by Democratic Congressman Emanuel Cleaver. Governor Mike Kehoe signed the new map into law, and President Trump celebrated the move publicly on social media. The Missouri Supreme Court rejected an early challenge to the map in March 2026, but opponents gathered nearly 3 times the signatures required to place a referendum on the November 2026 ballot, asking voters to repeal it outright, even after it has already been used once. A separate case, seeking to freeze the map until that referendum result is known, was still working through Missouri's courts this spring. North Carolina passed its own new lines in October 2025, and Ohio Republicans struck a deal with Democrats on a previously scheduled redraw that ultimately gave the GOP only 1 or 2 additional seats, far less than some in the party had originally wanted. It was 3 months ago tonight. Redraw produced a new district that leans Democratic, an outcome that cut against the broader Republican trend and shows the fights are not moving in only one direction. In response to the Republican maps, California Democrats, led by Governor Gavin Newsom, put a new Democratic favoring map before voters in a special election on November 4, 2025, overriding the state's independent, voter-created redistricting commission. The measure passed, and analysts estimate it could allow Democrats to win as many as 47 of California's House seats, up from 43, effectively canceling out much of the advantage Republicans built in Texas. The California Republican Party challenged the new map at the Supreme Court, which declined to intervene, letting it stand. Indiana became its own extended drama. Vice President J.D. Vance met personally with Governor Mike Braun and state lawmakers to push a new map targeting the state's 2 Democratic-held seats, with reporting suggesting the White House was also using pressure over federal resources to move reluctant legislators. The Indiana House ultimately passed a new map in the state legislature, but state Senate Republicans, some of whom face their own primary challengers over the issue, declined to advance it, and Indiana Republicans who had resisted the president's redistricting push lost to Trump-backed primary challengers as a direct consequence, a result South Carolina lawmakers were reportedly watching closely as they weighed their own decision on the Clyburn map. Illinois Governor J.B. Pritzker said his state's own redistricting plans hinged largely on what Indiana did, and after Indiana Republicans balked, Pritzker said on social media he would remain vigilant against what he called the president's map-rigging effort, even as Illinois faced its own complications, including a filing deadline for candidates that had already passed by early November. Virginia Democrats, who hold a narrow 6-5 delegation edge, passed a constitutional amendment allowing temporary mid-decade redistricting, a measure that has to clear the legislature a second time before going to voters, likely later this year, before any new Virginia map could take effect. Maryland, Florida, Nebraska, and Kansas have all, at various points, floated their own redistricting moves, either to join the fight or to respond to it, though as of this summer, none of the 4 had enacted new maps. Kansas House Speaker Dan Hawkins said publicly he would not bring redistricting legislation up for a vote at all this session, citing a lack of votes to override an expected veto from the state's Democratic governor. Ballotpedia's running tally puts the scale of this in context. Before 2025, only 2 states had voluntarily redrawn congressional maps mid-decade in more than 50 years. By early 2026, 6 states already had new maps in place, 3 more were actively exploring the same move, and courts in at least 3 additional states were actively deciding whether existing maps could survive legal challenge before the midterms. Common Cause's senior policy director, Dan Vicuna, described the overall pace using a single word: wildfire. That is the broader battlefield the Calais decision landed on. And here's the plain English version of why the decision matters so much to that fight specifically. Before Calais, if a state tried to weaken Black or Latino political power through a new map, Section 2 lawsuits stood a real chance of forcing that map to be redrawn, using the "does this produce a discriminatory result" test. After Calais, plaintiffs challenging a map now have to clear the much higher bar of proving discriminatory intent, while states can lean on the simple, hard-to-disprove defense that the map was drawn purely for partisan advantage, not racial advantage. Alabama is the clearest example of Calais reaching backward into a fight that had already been through the Supreme Court once before. Back in 2023, in a case called Allen versus Milligan, the Supreme Court itself ruled that Alabama's map violated Section 2 and ordered the state to draw a second district, giving Black voters a real opportunity to elect their preferred candidate. Alabama's legislature responded by passing a new map that still contained only one such district. A federal court rejected that map too, and a court-appointed special master drew the replacement map Alabama actually used in the 2024 election, the one with 2 Black opportunity districts. The case kept moving through the courts, and in May of 2025, after a full trial, a federal panel ruled again that Alabama's original 2023 map violated both Section 2 and the Constitution, finding the legislature had acted with racial intent. Then Calais happened. State officials began arguing that their map had been drawn for partisan reasons, not racial ones, leaning directly on the new legal opening the Calais decision created. It was 3 months ago tonight, June 2nd, 2026, the Supreme Court, in an unsigned 6-3 order, paused the lower court's ruling and allowed Alabama to use its 2023 map, the one already found twice, to intentionally discriminate against black voters for a rescheduled August primary and the general election beyond it. Justice Sotomayor dissented in a separate opinion. Democratic Congressman Shomari Figures, who represents Alabama's newer Black Opportunity District, said the decision set the country back decades and that too many people had fought and sacrificed for him to simply walk away from the seat. The Milligan plaintiffs, in a joint statement, said that when politicians worry about staying in power, they come for black voters first, and that their fight for fair representation was not over. The underlying case remains on appeal, with a retrial scheduled for no later than January 2027, which means Alabama's map for this November was decided on an emergency, temporary basis, not a final resolution of whether it is lawful. But the problem, for anyone assuming this is a simple story of one party winning and one party losing, is that it genuinely is not that simple, and a fair accounting of this story has to include the other side's argument, because it is a real argument made by real lawyers and elected officials, not a straw man. Here's the counter-argument, stated as its strongest defenders would put it. Justice Alito's majority opinion argues that lower courts had, for years, stretched Section 2 into something close to a mandate, forcing states to engineer districts around race in ways that themselves risk violating the Constitution's promise of equal protection, regardless of race. In that view, a state that draws a district to guarantee a black or Latino electoral majority is doing exactly what the 14th Amendment is supposed to prevent, sorting citizens by race and assuming their political interests based on that sorting. Republican officials in states like Texas have defended their new maps as legitimate partisan gerrymanders, not racial ones, arguing openly that districts were redrawn to protect incumbents and maximize seats for their party, a practice both parties engage in, and that the Supreme Court has previously said federal courts have no role policing, so long as race is not the predominant factor. Georgia Senate Leader Larry Walker put it plainly, saying he expects the state's eventual maps to survive legal scrutiny because they will be built on ordinary political considerations, not racial ones. Texas Governor Abbott described his state's map as a fair reflection of population growth and a step toward what he called strong conservative leadership in Washington. And it is true that Democratic-led states, California most prominently, have pursued their own mid-decade partisan redistricting for explicitly partisan reasons, which Republicans argue undercuts any claim that only one party is willing to bend district lines for advantage. There is also a fairness argument Republicans make that deserves to be stated plainly rather than dismissed. Both parties play this game. California's mid-decade map was drawn explicitly to help Democrats, using the same basic playbook, mid-cycle redistricting for partisan gain, that Republicans used in Texas and Missouri. If courts are going to police one party's map drawing as illegitimate, defenders of the Calais decision argue, consistency requires applying the same scrutiny to the other party's maps too, and the Constitution's Equal Protection Clause, on its face, does not pick sides between red states and blue states. Some legal conservatives have also pointed out that Section 2's older, results-based test put judges in the position of designing districts themselves, deciding how many majority-minority seats a state effectively owed different communities, a role critics on the right have long argued unelected courts were never meant to play in the first place. Civil rights groups reject the idea that partisan and racial motives can be neatly separated in states with deep racial polarization in voting patterns. MALDEF's Vice President of Litigation, Nina Perales, argued in a public statement that treating partisan advantage and racial targeting as unrelated ignores how entangled the two have become in practice, and that when a party has almost entirely alienated a racial group's voters, the answer under a healthy democracy should be to earn that group's support, not to draw them out of political relevance. Voting rights advocates also note an asymmetry the both sides do it argument tends to skip over. California's map did not eliminate the state's only black-held or Latino-held districts, while the maps in Tennessee and the ones attempted in South Carolina and Georgia targeted the only black-held seat in each state specifically. Whether that distinction matters legally is now, after Calais, largely up to individual judges applying an intent standard that has never been tested at this scale before. That is the heart of the dispute. Is this a story about ordinary hardball politics that happens to fall along racial lines because of how Americans currently vote? Or is it a story about race being used as a tool for partisan ends, with partisan advantage offered up as the legal shield? Courts, going forward, will decide that question state by state, map by map, under the new and much higher bar Calais created, and reasonable, informed people, including sitting federal judges, currently disagree on the answer. More evidence if you want it in raw numbers. Ballotpedia's tracking shows that, as of early 2026, 6 states had already adopted new congressional maps ahead of the midterms, and additional states were actively exploring the same move, a pace of mid-decade redistricting the country has not seen since the 1960s, before the Voting Rights Act itself reshaped the ground rules. Before 2025, only 2 states had voluntarily redrawn congressional maps mid-decade, going back more than half a century. Voting Rights Lab, a nonpartisan tracking organization, documented lawsuits challenging new maps in at least 8 states by the spring of 2026, with courts in Texas, California, and North Carolina reaching different conclusions on whether new lines counted as permissible partisan gerrymanders or unconstitutional racial ones, exactly the split Calais was supposed to resolve, and arguably did not. It's also worth noting how unusual it is for redistricting fights to generate this kind of turnout data at all. In most election cycles, district maps are finalized years before anyone votes on them, so there is no clean way to measure whether a specific map change moved specific voters to the polls. This cycle is different precisely because so many maps were finalized mere weeks before primaries voters had already circled on their calendars, creating a rare, almost real-time experiment in whether contested redistricting itself can drive turnout. Compare the turnout numbers across the 3 southern states this video has focused on, and a pattern emerges that pollsters and campaign strategists are watching closely heading into November. In South Carolina, early voting on the first day of the primary ran nearly 5-1 in favor of Democratic ballots, in a state Republicans have carried in every recent statewide election. In Georgia, protest crowds numbering in the hundreds to low thousands were large enough to reportedly factor into legislative leaders' decision to shelve their own plan less than an hour before a scheduled vote. In Tennessee, general turnout stayed relatively ordinary statewide, but Shelby County's Democratic primary turnout came in at more than double the percentage recorded in a comparable contest just 2 years earlier. None of these are national polls. Each is a single data point from a single state, but 3 separate data points in 3 separate states, all pointing the same direction, is the kind of pattern campaign strategists in both parties take seriously when they are trying to model turnout for a competitive November. If you're finding this useful, this is the point in the video where I'd ask you to hit like and subscribe, because breakdowns like this take real research time, and the algorithm mostly shows this channel to people who are already subscribed. And if you disagree with any of what you've heard so far, genuinely, leave a comment and tell me why. I read all of them. Legal experts have not been shy about characterizing how big a shift this is. Analysts at SCOTUS blog described the ruling as reworking a legal framework that had stood since the 1986 Thornburg versus Gingles decision, the case that, for 40 years, set the basic test courts used to decide when a district illegally diluted minority voting strength. Writing for the Brennan Center for Justice, legal scholars noted that the 6-3 decision did more than resolve one Louisiana dispute. It reset the baseline test nationally, meaning every pending Section 2 case in the country now has to be re-argued or reconsidered under the new intent-based standard. Some legal commentators, including law professor Erwin Chemerinsky, questioned whether the court had effectively decided the case before the second round of oral arguments even happened, given how quickly the majority opinion followed after months of near silence. SCOTUS blog contributor Carolyn Shapiro, a law professor who has tracked the case since its first oral argument, questioned in an essay published before the ruling whether Justice Alito was, in her words, jumping the gun on voting rights, given how far the eventual opinion reached beyond the narrow Louisiana dispute the court had originally agreed to hear. After the decision, Shapiro and others turned to writing essentially a how-to guide for advocates on fighting back within the new framework, focused on building the kind of detailed, intent-focused evidentiary record that Section 2 claims will now require. Other scholars, writing in the weeks after the decision, focused on a narrower but equally consequential question, whether Calais also quietly weaponized the Equal Protection Clause itself, turning a constitutional provision written to protect minority groups into one that can now be used to strike down the very maps drawn to help them. The NAACP Legal Defense Fund called the decision a devastating blow to a sacred civil rights protection, while cautioning that Section 2 remains technically on the books, just far harder to enforce than it was 6 months earlier. Historians who study this period keep reaching for the same comparison, and it is worth sitting with for a moment. After the Civil War, during Reconstruction, black men across the South were elected to Congress, to state legislatures, to local offices, in numbers that would not be matched again for 100 years. That progress did not end because voters changed their minds. It was 3 months ago tonight. It ended because once federal troops withdrew and federal oversight faded, so-called redeemer governments in southern states spent the following decades systematically rewriting election rules through literacy tests, poll taxes, and yes, through district lines, to push black office holders out of power and keep them out. It took nearly a century, and the Voting Rights Act itself, to reverse that. Nobody serious is arguing the current moment is identical to the 1870s and 1880s. The comparison historians draw is narrower and more specific. It is a reminder that federal legal protections for minority political power have been rolled back before in American history, gradually, through procedural and legal channels rather than open violence, and that the consequences took generations to undo. That is the historical weight sitting underneath what might otherwise sound like a dry legal story about district lines. It's worth being precise about what is settled and what is still an open question here, because overstating either side of this does a disservice to viewers trying to understand it. What is settled? The legal test for proving a Section 2 violation is now dramatically harder to meet. The ruling applies nationwide, not just to Louisiana, and states currently controlling the redistricting process have far more legal room to draw maps that reduce minority representation than they did 1 year ago. What is not settled, exactly how high the new bar turns out to be in practice, since almost no lower court has yet finished applying it to a real case, whether the Thomas concurrence's more sweeping view eventually attracts a majority, and whether states that draw maps this aggressively will still lose in court on ordinary constitutional grounds having nothing to do with Section 2 at all, the same grounds that struck down Louisiana's second majority black district in the first place. Here's the real-world consequence. In terms anyone can picture, Voting Rights Lab's national tracking, combined with reporting from NBC News and the Associated Press, suggests the current wave of mid-decade maps could shift more than a dozen U.S. House seats nationally before the 2026 midterms are even held, split across both parties, but concentrated in Republican-controlled southern states, where the new Calais standard gives legislatures the most room to maneuver. In Tennessee alone, a single district that has elected a black Democrat for years now leans firmly Republican. In Texas, the new map is projected to yield as many as 5 additional Republican-friendly seats. Alabama's map, allowed to stand despite a lower court finding of racial discrimination, keeps in place lines a federal panel had already ruled diluted black voting power. Missouri's map, if it survives the November referendum, removes another reliably Democratic, urban-anchored seat from the map. Multiply that pattern across a handful of southern and Midwestern states, and the practical effect, regardless of the legal reasoning behind it, is a meaningful reduction in the number of majority black or heavily black influenced districts represented by the candidates those communities actually chose. Zoom out to the national picture, and the stakes become clearer still. Republicans currently hold a narrow House majority, small enough that a swing of just a handful of seats decides which party controls committee chairs, the speaker's gavel, and the ability to set the agenda for the second half of President Trump's term. That is precisely why this redistricting cycle has been fought so hard by both parties, and precisely why the Calais decision matters so much to Republican strategists specifically. A legal standard that makes it harder to challenge maps that reduce black representation is also, mechanically, a standard that makes it easier for Republican-controlled Southern legislatures to convert black-held Democratic seats into Republican-leaning ones, because those are disproportionately the seats being targeted. Democrats' main counter, so far, has been matching Republican mid-decade maps with their own in states they control, California most notably, rather than relying on Section 2 litigation, which is now a far less reliable tool than it was a year ago. That trade, one party's newly weakened legal shield against the other party's willingness to redraw its own maps just as aggressively, is the actual shape of the fight heading into November, stripped of the legal jargon. There is a second consequence that gets less attention but matters just as much: the effect on who runs for office at all. When a majority black district gets cracked into several whiter, more conservative districts, it does not just change who wins the general election. It changes who decides to run in the first place, because a viable black candidate in a now 30% black district faces a fundamentally different path to Congress than the same candidate would have faced in a 60% black one. Political scientists who study representation describe this as a pipeline effect, one that can take a full decade or more to reverse even if maps are eventually redrawn again, because it interrupts the process by which local officials build the name recognition and fundraising networks needed to run for higher office. Here's where the story is still being written, because almost none of this is finished. Missouri's new map, which targets Kansas City Democrat Emanuel Cleaver's district, faces a voter referendum in November 2026 that could repeal it even after it has already been used in an election, a strange scenario where a seat's occupant could take office under one map and then find the legislature legally required to redraw it again the following year. Organizers opposed to the map gathered nearly 3 times the number of signatures required to force that referendum onto the ballot, a sign of the same kind of grassroots energy that showed up in South Carolina and Georgia, even though Missouri's fight has drawn less national attention than the southern redistricting battles this video has focused on. A separate Missouri lawsuit, seeking to block the new map until that referendum result is known, was still working through the courts as of this spring. The Alabama's underlying racial gerrymandering case remains unresolved on the merits, even after the court let the current map stand for this election cycle, with a retrial scheduled for no later than January 2027, which means the fight there is paused, not over, and a final ruling could still force a mid-cycle redraw before 2028. Georgia Republicans have said publicly they expect to return to redistricting once ongoing litigation elsewhere clarifies exactly how far the new Calais standard lets them go, meaning the special session that ended in cheers this June may only have delayed, not defeated, a second attempt, one that could resume as soon as next year's legislative session. South Carolina's map fight is similarly paused rather than resolved, since nothing in state law stops the legislature from bringing the Clyburn map back in a future session, particularly if Ralph Norman wins his campaign for governor this November and takes office with the same priorities he pushed as a legislator. Virginia's constitutional amendment allowing mid-decade redistricting still needs to clear the legislature a second time and go before voters, likely later this year, before any new Virginia map could take effect for these midterms at all. There is also a path around the courts entirely that gets mentioned less often than it should: Congress itself. Democrats have for years pushed a bill called the John R. Lewis Voting Rights Advancement Act, which would restore a modernized version of federal preclearance and give Section 2 back much of the strength Calais just took away, through ordinary legislation rather than judicial interpretation. Congressman Clyburn has pointed to that bill directly, along with proposals for independent, bipartisan redistricting commissions, as the kind of structural fix that would end this entire cycle of litigation, rather than fighting it map by map, state by state. The obstacle is arithmetic, not ideas. The bill needs 60 votes to overcome a Senate filibuster, and Republican support for it has been essentially non-existent, which means realistically, this legislative fix remains a talking point rather than a live option unless the composition of Congress itself changes substantially, which loops directly back to the same November elections being fought under the very maps this video has spent the last several minutes describing. And nationally, every one of these maps, in Texas, Missouri, Tennessee, Alabama, South Carolina, California, and beyond, will get its real test on a single day, November 3rd, 2026, when control of the U.S. House of Representatives, and with it the balance of power in Washington for the back half of President Trump's term, will be decided under the new lines this decision made possible. So where does that leave the people actually living inside these new districts? In Memphis, in Baton Rouge, in Montgomery, in the parts of South Carolina and Georgia that Republicans tried and failed to redraw? It leaves them roughly where the pattern from this spring and summer suggests, not waiting for a court to rescue them, and not assuming the fight is permanently lost either. South Carolina and Georgia show that a redistricting plan announced with confidence can collapse in weeks when enough voters show up angry and organized. Tennessee shows that even a map that passes can produce a primary turnout nobody expected and a candidate nobody thought could win the nomination. Alabama shows that even a map ruled discriminatory, twice by federal judges, can still be used in an election if the right emergency order lands at the right moment. None of that guarantees outcomes in November. Justin Pearson is running in a district that tilts against him. Missouri's new map might still survive its referendum. Alabama's case might still take years to resolve. But The through line connecting South Carolina, Georgia, and Tennessee is the same. The assumption that a weakened Voting Rights Act would translate automatically and quietly into weakened black political power turned out to be wrong, at least twice out of 3 times, and even in the state where it didn't hold, it produced the kind of grassroots mobilization that tends to outlast any single election cycle. If you're wondering what any of this means for you personally, especially if you don't live in Louisiana, Alabama, South Carolina, Georgia, or Tennessee, here is the practical version. First, check your own state's redistricting status, because this fight is not confined to the South. Virginia, Illinois, Maryland, Florida, Nebraska, and Kansas all have live or pending redistricting questions right now, and a map can move from proposal to law in a matter of weeks once a legislature decides to act, as South Carolina and Tennessee both showed this year. Second, primary elections, not just general elections, are where these fights are actually being decided this cycle, because a redrawn district often gets its first real test in a primary, exactly as it did in Memphis. Showing up in August or June, not just in November, is when your vote carries the most weight in a newly drawn seat. Third, if you want to track this without relying on any single source, nonpartisan trackers like Ballotpedia and Voting Rights Lab publish running state-by-state updates on exactly which maps are law, which are being challenged, and which elections will use them, updated far faster than most news coverage can keep pace with. Let's pull the whole picture together, because this is a lot to hold at once. In April, the Supreme Court rewrote the legal test for Section 2 of the Voting Rights Act, requiring proof of intentional discrimination instead of simply proving a discriminatory result. Within weeks, that ruling collided with a redistricting arms race that was already underway in more than a dozen states, driven by a simple partisan fact. Control of the U.S. House in 2026 is expected to be decided by a handful of seats. In South Carolina, an attempt to eliminate the state's only black-held seat collapsed after record early voting turnout. In Georgia, a similar attempt collapsed the same day it was scheduled to begin, after protesters filled the Capitol. In Tennessee, the attempt succeeded, the district was broken apart, and Memphis organizers responded by driving Democratic primary turnout to its highest level in a decade, nominating a candidate who now faces a genuinely difficult November race. In Alabama, a map found to be intentionally discriminatory not once but twice is being used anyway on an emergency temporary basis while the underlying case heads toward a retrial. And nationally, Texas, Missouri, California, North Carolina, Ohio, and Utah have all changed their maps too, for reasons that range from openly partisan to constitutionally contested, meaning this single Supreme Court decision is touching congressional representation in more states for more people than almost any ruling in recent memory. The Supreme Court changed the legal rules on April 29, 2026. That much is settled, and it is not going to be undone by a single election or a single protest. But what this spring and summer showed, across 3 different southern states with 3 different outcomes, is that legal rules are not the only force operating on American elections. Turnout is still a force. Organizing is still a force. And in South Carolina and Georgia at least, that force was strong enough to stop a plan its own authors thought was already decided. Whether that holds true in November, in Tennessee, in Alabama, in Missouri, and in every other state still fighting over its lines, is the story this channel is going to keep following, because it is nowhere near finished. If you want the deeper, fully documented version of how we got here, remember that book is linked below, The American Reckoning, Trump, Power, and the Battle for America's Future. And if you want to be here when the next chapter of this particular story breaks, whether that's a ruling out of Alabama, a referendum result out of Missouri, or a November outcome out of Memphis, you know what to do. Subscribe, leave a comment with your read on any of this, and I will see you in the next one.